This is the case Hayden versus the University of Notre Dame by Amy McDonald. This is for Sport Law in EDU 503 at William Woods University. This case is Hayden versus University of Notre Dame, William and Letitia Hayden, and they are appealing the trials court grant from the University of Notre Dame. It is at the Independent Appellate Court in 1999 from Chapter 2, Case Study 2.19 in Case Studies in Sport Law regarding tort law and product liability. The facts of the case, just a little bit of background. William and Letitia Hayden were attending a home football game at the University of Notre Dame on September 16th, 1995. They were business invitees, and during the second quarter of the game, one of the teams kicked the football towards the goal, and the net behind the goalpost did not catch the ball, so it landed in the stands close to where William and Letitia were sitting in the stands. Many people from the stands rushed and lunged for the ball in order to retrieve it, thus striking Letitia Hayden from behind, where she was knocked down, causing a shoulder injury. William and Letitia later testified in the appeal that this aggressive behavior has been witnessed before, and that the net behind the goalpost caught the ball only about 50% of the time that it was kicked, and the other half of the time, people in the seating area were frantically, aggressively trying to retrieve the ball, which is what happened here on September 16th to the Hayden family. Originally, this case was ruled in favor of Notre Dame University, but the Haydens appealed, which is how it got brought to the Independent Appellate Court in 1999. They claim that negligence was a part of this, so just some facts about negligence, that in order to support it, these three things must be proven. So they had to prove that Notre Dame owed a duty to protect Letitia. They also had to prove that Notre Dame failed to uphold their duty to protect her, and also that she sustained her injury because of the fact that the university failed to uphold their duty to protect her. Arguments from both sides of the case are that William and Letitia Hayden said that the University of Notre Dame has a duty to protect their invitees, and here where Notre Dame was negligent in failing to protect Letitia in the stands. However, the University of Notre Dame argues that they are not responsible for the criminal acts of a third party, that they cannot foresee acts that a third party may commit during these games, so therefore they owed no duty to anticipate that Letitia Hayden would suffer any injuries or bodily harm as a business invitee of the university. So the court findings in this related to this case was that the Supreme Court recently decided many cases that articulated the test for deciding cases regarding the landowner and their duty to protect invitees against third parties. So one of the cases was Tau Delta versus Johnson, which was in the same year, 1999. They had to adopt a totality of circumstances test to see if the foreseeable criminal acts against invitees, to see if it was actually foreseeable. So the court considered all the circumstances surrounding that event, which were related to this case, including the nature, the condition, the location of the land, as well as prior similar incidences. So the court decides if they take all these things into consideration to see whether or not this was foreseeable and to see if the University of Notre Dame could have, in fact, protected Letitia Hayden as she was an attendee of the University of Notre Dame football game. As mentioned earlier, the case was originally ruled in favor of the university, and it was found that the trial court erred in finding that no duty existed for Notre Dame, so that's how we came to this appellate court between the Haydens and the university. So on appeal, it was reversed in favor of the Haydens, and they decided that the University of Notre Dame owed Letitia Hayden a duty to take reasonable steps to protect her from injury. This is based on other rulings in other cases that had happened previously regarding that totality of circumstances test. So, as a future athletic administrator, there are things that you can take after reading and analyzing this case that can be important in your program and moving forward that I'm sure the University of Notre Dame took in these steps. As athletic directors, we need to be able to foresee events that could happen like this. So knowing that these things have happened in the past and knowing that they could happen anywhere, not just at large universities, even at high school level games where there's fans who may have access to errant balls, pucks, etc. So you need to have a plan in place for these events in order to reduce the risk of this happening. So having a prior emergency plan, what we would do if this could take place, and how in the future, how you can have a plan to prepare for these things just in case something like this does happen. So going off of that prior planning can prevent negative outcomes. So if you have a plan in place and you are aware that this may happen, the people are less likely to be able to sue you for negligence because of your preventive state.